Something absolutely massive is happening right now in American gun law that almost nobody is paying attention to. Magazine capacity limit laws, the ones that restrict how many rounds you can have in your gun, are being challenged and struck down in courts all across the country. We are talking about laws that have been on the books for 20, 30, even 40 years suddenly being declared unconstitutional. States like California, New York, New Jersey, and others spent decades building these restrictions, and now they are watching them fall apart one by one. If you own guns, if you care about Second Amendment rights, or if you just want to understand why gun laws are changing so dramatically right now, you need to hear this story, because what is happening with magazine limits is going to affect dozens of other gun laws in the near future. So let me break down exactly what magazine capacity laws are, why they were created, what courts are saying about them now, and most importantly, what this means for gun owners in states that have had these restrictions for years. Let me start with the basics, because not everyone knows what we are talking about when we say magazine capacity limits. A magazine is the part of a gun that holds ammunition. It feeds rounds into the firearm so you can shoot multiple times without having to reload after every shot. Magazines come in all different sizes. You can have magazines that hold 5 rounds, 10 rounds, 15, 20, 30, even more depending on the type of gun. Now here is where the controversy comes in. Starting in the 1980s and 1990s, some states and eventually the federal government started passing laws that limited how many rounds a magazine could hold. The most common limit was 10 rounds. The idea behind these laws was that limiting magazine capacity would reduce the lethality of mass shootings. The theory was that if a shooter had to reload more often, it would give people time to escape or give law enforcement time to intervene. It sounded reasonable to a lot of people, and so these laws spread. California passed magazine limits, New York passed them, New Jersey, Connecticut, Massachusetts, Maryland, Colorado, Hawaii, and several other states followed. For a while, there was even a federal ban on magazines that held more than 10 rounds. That federal ban was part of the assault weapons ban that passed in 1994, but it expired in 2004 and was never renewed. However, many states kept their own magazine limits in place even after the federal ban ended. Now fast forward to today, these magazine capacity laws are under serious legal attack, and many of them are losing in court. Why? Because of that Supreme Court decision I have talked about before, the Bruen decision from 2022. Remember, Bruen established a new legal test for gun laws. It said that any restriction on Second Amendment rights has to be consistent with a historical tradition of firearm regulation in America. If there is no historical precedent for a particular type of restriction, then that restriction is probably unconstitutional. And here is the problem for magazine capacity laws. There is absolutely no historical precedent for limiting how much ammunition a gun can hold. Let me explain why. Back in 1791, when the Second Amendment was written, the most common firearms were muskets and flintlock pistols. These were single-shot weapons. You loaded one round, you fired, and then you had to go through a lengthy reloading process before you could fire again. There were no magazines. The concept did not exist yet. But here is what is important. The Founding Fathers knew about technological advancement. They knew that weapons technology was improving. In fact, there were already some early repeating firearms being developed in that era, and nowhere in any historical record from the founding era is there evidence that governments tried to limit how much ammunition someone could carry or how quickly they could fire. The idea of limiting capacity simply was not part of the historical tradition of gun regulation. So when modern courts apply the Bruen test to magazine capacity laws, they are asking, is there a historical tradition of limiting how much ammunition a person can have in their firearm? And the answer they are finding is no, there is not. And that is why these laws are starting to fall. Let me give you some specific examples of what is happening right now. In California, there is a case called Duncan versus Bonta that has been going on for years. This case challenges California's ban on magazines that hold more than 10 rounds. And this case has had a wild ride through the courts. A federal district judge struck down the ban and said it was unconstitutional. Then an appeals court panel agreed with him. Then the full appeals court reversed that decision and said the ban was okay. Then the Supreme Court sent the case back down to be reconsidered in light of the Bruen decision. And now the lower courts are looking at it again with the historical test in mind. Legal experts expect that when all is said and done, California's magazine ban is probably going to be struck down permanently because it cannot meet the historical tradition test. The same thing is happening in New Jersey. New Jersey has one of the strictest magazine limits in the country. They do not even allow 10 rounds. New Jersey's limit is 10 rounds for rifles, but only 10 rounds for handguns as well, and they have additional restrictions that make it even more complicated. But right now, there are multiple lawsuits challenging New Jersey's magazine limits, and those lawsuits are using the Bruen framework. They are arguing that there is no historical justification for these limits, and therefore they violate the Second Amendment. Courts have not issued final rulings yet, but the writing is on the wall. If California's ban falls, New Jersey's ban is almost certainly going to fall too, because they are based on the same logic and they face the same historical problem. New York is in a similar situation. After the Bruen decision, New York tried to keep as many gun restrictions in place as possible. They amended some laws and added new ones, but their magazine capacity limit is still being challenged. And again, the challenge is based on the argument that there is no historical tradition supporting magazine limits. Colorado, Connecticut, Maryland, Massachusetts, Hawaii, all of these states have magazine limits, and all of them are potentially vulnerable to legal challenges under the Bruen framework. We are talking about laws that affect tens of millions of people across multiple states, and they are all under threat right now. If this is blowing your mind and you are realizing just how much is changing in gun law right now, do me a favor, hit that like button. Seriously, it helps the algorithm. Push this video to more people who need to understand what is happening. And if you have not subscribed yet, click that subscribe button because we are covering these major legal changes as they happen. Also, share this video with any gun owners you know, especially if they live in states with magazine limits, because they need to know that the law is shifting in their favor. All right, let us keep going. Now, let me address the arguments on the other side, because this is not a one-sided issue. People who support magazine capacity limits make several arguments. They say that limiting magazine capacity can save lives in mass shooting situations. They point to cases where shooters were stopped or slowed down when they had to reload. They argue that ordinary citizens do not need high-capacity magazines for self-defense or hunting. And they say that even if there is no historical precedent from 1791, the government should be able to adapt gun regulations to modern circumstances. These are serious arguments that a lot of people find persuasive. But here's the problem. Under the legal framework that the Supreme Court established in Bruen, these arguments are not enough. The court was very clear that modern policy preferences and public safety concerns alone cannot justify restrictions on constitutional rights. There has to be a historical foundation. And for magazine limits, that foundation simply does not exist. Now, let me give you another angle on this. Supporters of magazine limits often talk about high-capacity magazines as if they are some unusual military feature that civilians should not have. But here's the reality. For many modern firearms, what gets called a high-capacity magazine is actually just the standard magazine that the gun was designed to use. Take the Glock 19, one of the most popular handguns in America. It comes from the factory with a 15-round magazine. That is not high capacity. That is standard capacity for that firearm. The AR-15, America's most popular rifle, typically comes with a 30-round magazine. Again, that is standard. When states pass laws limiting magazines to 10 rounds, they are not just banning some exotic accessory. They are forcing gun owners to use reduced capacity magazines that make their firearms less effective for self-defense. And that is exactly why courts are skeptical of these laws. They see them as substantial burdens on Second Amendment rights that cannot be justified by historical tradition. Now let me talk about what this means practically for gun owners. If you live in a state with magazine capacity limits, you might be wondering, can I go out and buy standard capacity magazines now? The answer is not yet, not until a court officially strikes down the law in your state. Even if similar laws are being struck down elsewhere, the law in your state is still enforceable until a court says otherwise. So you have to be patient. But the legal momentum is clearly on your side. Cases are moving through the courts, and it is very likely that within the next year or two, many of these magazine bans are going to be gone. When that happens, gun owners in restricted states are going to be able to legally purchase and possess magazines that they have been prohibited from having for decades. That is a huge change. Let me tell you about another aspect of this that people do not often think about. Magazine capacity laws did not just restrict what you could buy. In many states, they also criminalized possession of magazines that people already owned. California's law, for example, required people who owned magazines over 10 rounds to either turn them in, destroy them, sell them out of state, or modify them to accept only 10 rounds. Imagine owning something completely legal, and then the government passes a law saying you are now a criminal if you keep it. That is exactly what happened to hundreds of thousands of gun owners in California and other states. When these laws get struck down, those people are going to be vindicated. They are going to be able to retrieve magazines they had to give up, or buy back the standard capacity magazines they were forced to get rid of. Here's something else that is interesting. The failure of magazine capacity laws in court is having a ripple effect on other gun laws, because if courts are saying that magazine limits cannot be justified under the historical tradition test, what about other restrictions that also have no historical precedent? What about assault weapons bans that prohibit certain cosmetic features on rifles? What about waiting periods that force you to wait 10 days before picking up a gun you purchased? What about laws that limit how many guns you can buy in a month? All of these laws were passed in the late 20th century. None of them have historical precedent from the founding era, and all of them are now vulnerable to the same type of legal challenge that is bringing down magazine limits. We are seeing this play out in real time. Assault weapons bans are being challenged and in some cases struck down. Waiting period laws are being challenged. The entire framework of modern gun control that was built up over the past 30 or 40 years is being systematically dismantled by courts applying the Bruen standard. Let me give you a sense of the timeline here. The Bruen decision came down in June of 2022. Within months, Second Amendment advocacy groups filed new lawsuits or asked courts to reconsider old cases in light of Bruen. By late 2022 and into 2023, we started seeing courts strike down various gun laws using the historical tradition test. Magazine capacity bans were among the first to fall because they are so obviously lacking in historical support. As we move through 2024 and into 2025 and 2026, we're going to see more and more decisions. Some cases will go all the way back to the Supreme Court for final resolution, but the direction is clear. Magazine capacity. Limits are on their way out, and they are taking a lot of other gun restrictions with them. Now, I want to pause here and remind you one more time. If you are getting value from this breakdown of what is happening in gun law, smash that like button. Subscribe to the channel so you do not miss updates as these court cases develop. And share this video with anyone who needs to understand how the legal landscape is changing. This stuff matters, and most people have no idea it is even happening. All right, let us keep going. Let me talk about the political response to all of this because it is fascinating. Politicians in states with strict gun laws are not happy about what is happening in the courts. They see decades of gun control legislation being undone by judges, and they are looking for ways to fight back. Some states are trying to pass new laws that they think might survive legal challenges. They are looking for any historical precedent they can find to justify restrictions. Some are arguing that certain modern locations are analogous to historical sensitive places where guns could be restricted. Others are trying to redefine what counts as a dangerous weapon or a dangerous person to create new categories of prohibition. But here is the problem they are running into. The more restrictive they try to be, the harder it is to find historical support. And courts are not being fooled by superficial attempts to create analogies where none really exist. The historical record is what it is, and you cannot just make up traditions that did not exist. On the other side, you have gun rights advocates who are feeling emboldened. They are filing lawsuits challenging laws they never thought they could beat. They are pushing for even more expansive interpretations of the Second Amendment, and they are winning more often than they are losing. This has created a dynamic where the political branches of government are trying to restrict gun rights, while the judicial branch is expanding them. It is a constitutional clash that is going to define gun policy in America for years to come. Let me bring this back to what it means for you as an individual. If you are a gun owner in a state with magazine capacity limits, stay informed about the lawsuits in your state. Follow Second Amendment organizations that are doing this litigation work. When a court strikes down the law in your state, there may be a brief window where you can legally acquire standard capacity magazines before the state tries to appeal or pass a new law. You want to be ready to act when that window opens. If you are not a gun owner, but you care about constitutional rights, this is still important to you. The principles being applied in these gun cases affect how we interpret all constitutional rights. The idea that rights have to be respected unless there is a strong historical and constitutional justification for restricting them is a principle that applies beyond just guns. It affects how we think about government power and individual liberty in general. Whether you support gun rights or gun control, it is important to understand what is actually happening in the legal system rather than just relying on partisan talking points. Gun control advocates often say that the courts are ignoring public safety and putting people at risk. Gun rights advocates say the courts are finally respecting the Constitution after decades of infringement. The truth is that courts are applying the legal standard that the Supreme Court established, and that standard requires historical justification for gun restrictions. You can agree or disagree with that standard, but that is the law right now. And magazine capacity limits are failing that test because there is no historical tradition of limiting how much ammunition a firearm can hold. Here's what I predict is going to happen over the next few years. More magazine capacity bans are going to be struck down. California's ban will probably fall. New Jersey's will follow. New York, Connecticut, Maryland, Colorado, Massachusetts, Hawaii, they are all going to face successful legal challenges. Some states might try to pass new laws with slightly different approaches, but those will get challenged too. Eventually, the Supreme Court is probably going to take up a magazine capacity case directly, and issue a definitive ruling that applies nationwide. When that happens, magazine capacity limits will be effectively dead as a form of gun control. States will have to accept that they cannot restrict magazine size, just like they had to accept after Bruen that they cannot require special need or proper cause for concealed carry permits. It is a fundamental shift in how gun rights are understood and protected in America. Now, let me address one more thing. Some people worry that striking down magazine limits will lead to more gun violence. That is a legitimate concern, and it deserves a serious response. The evidence on whether magazine limits actually reduce violence is mixed at best. Some studies claim they have a small effect. Other studies find no effect at all. What we do know is that magazine limits do not stop criminals from getting high-capacity magazines if they want them. There are millions of standard capacity magazines already in circulation. They are easy to make. They can be imported illegally. So the people who are most likely to follow magazine limit laws are law-abiding gun owners, while criminals simply ignore the laws. That is one reason why courts are skeptical of these laws. They burden the rights of law-abiding people without effectively addressing the problem they are supposed to solve. But again, under the Bruen framework, even if magazine limits were highly effective at reducing crime, that would not be enough to justify them if there is no historical tradition supporting them. Constitutional rights are not subject to cost-benefit analysis. They exist to protect individual liberty even when restricting that liberty might produce some public benefit. Let me wrap all of this up. Magazine capacity limit laws are falling apart because they cannot meet the historical tradition test that the Supreme Court established in the Bruen decision. These laws, which have been in place in multiple states for decades, are being struck down one after another. Gun owners in restricted states are going to regain the ability to possess standard capacity magazines. And this is not just about magazines, it is about a fundamental reordering of gun law in America. The era of states being able to pass gun restrictions based solely on modern policy preferences is over. Now every restriction has to be justified by historical tradition. And many restrictions, including magazine limits, simply cannot meet that standard. So if you're a gun owner, this is a huge win. If you support gun control, this is a major setback. But either way, this is the reality we're living in, and it is important to understand what is happening and why. Thank you so much for watching this video. If it helped you understand what is happening with magazine capacity laws and why they're being struck down, please hit that like button one last time. Subscribe to the channel for more coverage of these developing legal issues. And share this with anyone who needs to know that the gun law landscape is changing dramatically. I will see you in the next video. Stay informed, stay aware of your rights, and keep watching as this legal revolution continues to unfold.